Good morning, Ms. Richards.
Good morning, sir.
Now, you're going to tell us a little bit more about this week and what to expect and what not to expect, I think.
I am, sir. So this morning I'll be talking a little about Skipton documents and the Skipton decision-making processes. This afternoon we have Anne Lloyd, Chair of the Caxton Foundation. We then have Nick Fish on Tuesday, Administrator to the Skipton Fund, also with some involvement with Macfarlane and Caxton Foundation. We have Professor Howard Thomas on Wednesday, Trustee of Caxton and Director of Skipton. Then on Thursday we have Professor Mark Mildred, Skipton Appeals Panel Chair, and then Charles Lister, who we anticipate will start on Thursday but probably continue on to Friday, who was a Trustee of the Caxton Foundation. Now, with the exception of Mr. Fish, those other witnesses all potentially have evidence to give which is relevant to other aspects of the inquiry's terms of reference. And I just wanted to explain what the inquiry is doing in relation to that, so that everyone is clear what they will or will not be asked about this week. Mr. Lister...
It's important they should know that, because if they have questions for you to ask, they need to know that if the questions relate to the parts which you're not covering in questioning this week, there is another opportunity to ask them at a later stage, and that's when they should be put forward to you for consideration.
Exactly, sir. So in relation to Mr. Lister was head of blood policy at the Department of Health from 1998 to 2003. We're not going to be asking him questions about his work for the Department of Health this week. We will be asking him to provide a further statement, and we anticipate it's likely to be a fairly substantial statement about that work. And it is likely that he will be called again to give oral evidence at a later hearing when you are hearing evidence more generally as regards government decision-making. So the questions this week will simply be arising out of his connection with and his work for the Caxton Foundation, but we are very alive to his significance as a witness more generally in relation to the Department of Health. Professor Mildred will also only be asked this week about his time as chair of the Skipton Appeal Panel. He was, as many people listening will know, one of the lead solicitors for the plaintiffs in the HIV litigation, and the inquiry intends to ask him to provide a further witness statement to it in relation to those matters, so he won't be asked about that this week. In relation to Ms. Lloyd, some core participants have suggested some questions which arise out of her role with NHS Wales. Those are going to be picked up through a request for a further witness statement. So again, when she gives evidence today, the questions will focus upon her role with the Caxton Foundation. The one witness with whom we're taking a slightly different course is Professor Howard Thomas. He will be asked this week both about his role with the Caxton Foundation and the Skipton Fund, and more generally about his work in the field of hepatitis. And there's no intention to recall him to give further oral evidence. So that's the position in relation to this week's witnesses, sir.
Yes, thank you very much.
So I'm going to turn then to the Skipton Fund. The inquiry has been investigating the decision-making of the Skipton Fund, in particular through analysis of applicant beneficiary files, with a specific focus upon applications that were rejected. The written note that we have prepared and which has been provided to core participants summarises what's emerged from those investigations so far, and also provides some context and background in relation to the Skipton Fund in advance of the oral evidence we'll hear tomorrow and in the course of the week. What I'm going to do this morning is really just talk about some of the documents and some of the data that has emerged in the course of the inquiry's investigation. In terms of key dates, the Skipton Fund started operations on the 5th of July 2004 and continued until 2017 when its functions were transferred to each of the four infected blood payment schemes administered by the four national administrations. It operated a formal appeal panel, so again a contrast with what we've heard about the other trusts thus far. The appeal panel held its first meeting in October 2006. And again, we'll be looking a little this morning at how it operated, but in more detail with Professor Mildred when he gives his oral evidence this week. If I can just start with a couple of documents which assist with understanding the background to the establishment of the Skipton Fund. Shomik, could we have NHBT 0015207_002? My screen isn't working, I'm afraid. Thank you. Got absolutely nothing coming up on it. Sorry, sir. Is your screen working?
It is, yes.
Well, I can start because I've got hard copies of the documents, so I'll just have to look at the large screen to check it's the correct one. So this was the announcement in relation to England by the then Health Secretary John Reid, 29th of August 2003. And it's now working. We can see in the second paragraph, it says, Mr. Reid said, after becoming Secretary of State, I looked at the history of this issue and decided on compassionate grounds that this is the right thing to do in this situation. I have therefore decided in principle that English hepatitis C sufferers should receive ex gratia payments from the Department of Health. And you'll see there, sir, the phrase ex gratia payments, which we are familiar with from the evidence we've heard so far about the other trusts and schemes. And the reference to this said to be a decision based upon compassionate grounds. The press release records that the details of the payments have yet to be worked out. This was clearly, as we can see, an announcement in relation to England on the 29th of August 2003. Similar announcements were made in relation to Scotland, Wales and Northern Ireland by the respective administrations. And I'll look in a minute at how the scheme came to be a UK-wide scheme, ultimately administered by the Department of Health in London, when we look at the agency agreement. The Skipton Fund, as it became called, was incorporated on the 25th of March 2004 as a private company limited by guarantee without share capital. So that's its legal form and status. And its incorporation and the press release that we've seen followed the conclusion of litigation in the High Court and the judgment of Mr. Justice Burton in 2001 in A and National Blood Authority. But it also followed upon the publication of a report commissioned by the Scottish Executive in 2003, usually known as the Ross Report. We'll just look at that. It's HSOC 0020367. So we'll see it's the report of the Expert Group on Financial and Other Support, March 2003, and we can see it was commissioned by the Scottish Executive. If we go to what I think will be page 13 electronically. Yes, we can see the recommendations in relation to financial payments. There were a number of other recommendations which I'm not going to go through at this stage. But recommendation 1 was that the Scottish Executive should agree to make compensation payments, so you'll note there the word compensation rather than ex gratia, as a matter of urgency to all people who can demonstrate on the balance of probabilities that they received blood products or tissue from the NHS in Scotland before the dates when they were made HCV safe and who were subsequently found to be infected with the hepatitis C virus. And then we can see the specific recommendations: an initial lump sum of £10,000 to cover inevitable anxiety, stress and social disadvantage. So that would have encompassed all who were infected with hepatitis C, including what we will see referred to as natural clearers, who were ultimately excluded from the Skipton Fund scheme. And then an additional lump sum of £40,000 to those who develop chronic hepatitis C to cover pain and suffering. So all those who moved from the acute stage to develop chronic hepatitis C would receive an additional £40,000. And then at C, those who subsequently suffer serious deterioration in physical condition because of the hepatitis C infection, e.g. cirrhosis, liver cancer or other similar serious conditions, should be entitled to full compensation. This compensation should be calculated on the same basis common law damages, taking account of the payments made under A and B above. So the recommendation there you'll see for those who ultimately a similar cohort to those who became eligible for stage 2 payments under the Skipton Fund when established. The Ross Committee's recommendation was full compensation on a common law damages basis. And then if we look at D, we see provision there in the recommendations where those who had died, the above payment should still be made, but made to their executors. And then if we look at just at the bottom of the page at G, people who've become infected with hepatitis C as a result of the virus being transmitted from a person infected by blood products or tissue from the NHS in Scotland shall be entitled to compensation on a similar basis to those who've been infected directly in this manner. So effectively, partners, spouses would be treated in exactly the same way as those who were infected directly through receipt of the blood or blood products. So those were the primary recommendations of the Ross report in terms of the quantification of the compensation which was recommended.
Well, the way that is set out, it is very similar indeed to full liability compensation as it would be in the courts.
Yes, very similar. And we've seen the term compensation no doubt deliberately chosen by the Ross Committee. Now, the payments that were ultimately made pursuant to the scheme set up fell some considerable way short of these recommendations.
Well, they weren't assessed on a compensation basis.
They weren't, and obviously nothing for natural clearers who were effectively excluded from the scheme once it was fully up and running. And then we'll look at the quantification of the payments, but for those at stage 1 and stage 2, but very much less than the sums contemplated here, and not on a compensation basis at all. And clearly the extent to which the recommendations of the Ross report were considered by government decision makers and the reasons why those particular recommendations were not implemented will need to be explored with relevant government and civil service witnesses in due course. We do have some insight into some aspects of government thinking, however, from a document at SCGV 40256_020. And if we go to the next page, please, Shomik. If we carry on. That's it, thank you. So this is an email from Bob Stock, 11th of December 2003. So it's an internal Scottish Government document. It provides some insight into the thinking of the Scottish Government, but also some broader insight into the thinking behind the establishment of the Skipton Fund in place of the recommendations of the Ross Committee. So we can see it's entitled Hepatitis C from Blood Ex Gratia Scheme. So already we've gone from compensation through John Reed's announcement in August 2003 of ex gratia, and we see ex gratia is still the language used here. Details of proposed parameters and administration. A purpose to seek ministers' endorsement of the detailed parameters that will apply to the scheme and for the proposals for administering it. priority immediate, Department of Health are proposing that there is a joint announcement by the 4 UK health ministers on either 18th or 19th of December, and Mr Chisholm will wish to inform Cabinet colleagues before this. And then if you look at the under the heading discussion, the paragraph numbered 1, this minute outlines the proposals jointly agreed by officials of the Scottish Executive, DH, Welsh Assembly Government and Northern Ireland Administration. The basic parameters already announced in Scotland are retained, i.e. £20,000 basic award, £25,000 on reaching medical trigger, no payments to those who clear the virus spontaneously or to dependents of those who died before the 29th of August. And those are the features of what the Skipton Fund then provided, but are augmented to cover detail on eligibility, supporting evidence and on how the scheme would be administered. So although this is a Scottish Government document, it is said to reflect that which has been agreed by the 4 respective departments of health. If we go over for a further 2 pages, please, Shomik. We can see there proposed scheme parameters, and then we will see, and I'm not going to go through it paragraph by paragraph, but we'll see broadly what the Skipton Fund scheme was going to be and did become. So under the heading eligibility date, no payments in respect of people who died before the 29th of August 2003. And then in the next heading, eligibility for basic award of £20,000. So that's the stage 1 award as it became known. And the criteria are there set out. Potential beneficiaries will receive the basic award of £20,000 if they've been infected with hepatitis C as a result of being provided by the NHS with blood or blood products before September 1991. There we see the eligibility cut-off date. And then if we go over to what I think, Shomik, will be page 8. We can see here the proposed arrangements for the administration of the fund. Under the heading Single UK Scheme, it's proposed the 4 UK administrations operate essentially identical schemes with identical awards, and that the most efficient way of dealing with this is for payments on behalf of all 4 administrations to be handled as part of a single UK scheme administered by a single independent trust. And then in the next paragraph we learn why it's called the Skipton Fund. It's been suggested that this might be named Skipton Trust. It took the form ultimately of a limited company, as I've said, not a charitable trust. The basis for this is that the substantive negotiations between officials of the 4 administrations took place in Skipton House, London. And then if we see reference to the Macfarlane Trust, this is paragraph 3, having agreed to take on the task of setting up and administering the new trust. And you'll recall, so we've heard from Mr. Peter Stevens about his involvement in that. Financial arrangements, the 4 administrations would be billed by the trust for awards paid out to beneficiaries attributable to the relevant country. The logical method of attribution would be that the beneficiary had been infected as a result of treatment in that country, and then there's an alternative, which would be that the beneficiary was currently resident in that country. And then 5 tells us that the Department of Health would take the lead in dealing with the new trust. The 4 administrations would contribute to the establishment and running costs of the trust, and possibly also to an initial working capital fund. And then if we go to the next page, please, we see a heading Key Issues, Sensitivities. The Haemophilia Society has been made aware of the likely scheme parameters and believes them to be unacceptable. This is principally because they feel the awards are too low and because no payments are to be made to the dependents of those who died before the 29th of August. And then there's a reference to the Haemophilia Society's having recommended payments to the dependents of the deceased, and also the reference to the expert group. And it's recorded that the Macfarlane and Eileen trusts made such payments.
Well, indeed, it was part of the very original trust deed for Macfarlane that they should.
Yes. And then if we go down to presentation and parliamentary implications, in the event that all 4 UK health ministers agree that the scheme should proceed on the base described, then Press Health and special advisors will need to liaise urgently with the other administrations, particularly Department of Health, to develop a common approach to the media. This approach should attempt to emphasise positive aspects, compassionate gesture, that's the terminology used, non-bureaucratic path for making claims, independent nature of administration and scrutiny arrangements, whilst recognising that challenges will be made regarding award levels being too low and dependents of the deceased being excluded. And then if we go to the next page, please. If we look at the heading Commentary on Scheme Parameters Underlying Philosophy, we see this in paragraph 8. The underlying philosophy spelled out in previous public statements in Scotland is that establishment of the scheme is as follows. This is a compassionate gesture, not a tacit acknowledgement of liability or wrongdoing. As such, awards are ex gratia payments, not compensation. Expenditure on scheme has to be balanced against the needs of other healthcare priorities and the needs of other patients. This means only limited funding can be spared. Within the constraints of limited funding, the people who should be targeted for financial assistance are those who are still alive and suffering the adverse effects of being infected with hepatitis C. And whilst this obviously is, as it were, a discussion document, this does, I think, effectively reflect the way in which the Skipton Fund was, within the weeks and months that followed, set up and the basis upon which it operated. There's then a discussion about the medical trigger for the additional £25,000 award, so for the stage 2 payments. And then if we go to the next page, we'll see at the bottom of the page under the heading Commentary on Standard of Evidence, this is a theme I'll pick up in the course of the morning, the passage of time since the original infection means that potential beneficiaries face real problems in producing irrefutable evidence. In particular, clinicians who treated them may be retired or deceased, and hospitals may have difficulty in finding their medical records or may have legitimately destroyed them. In recognition of this, it is proposed that the lower standard of on the balance of probabilities, rather than beyond reasonable doubt, is adopted for evidence. And then paragraph 16 says it's certain that virtually all blood products produced from pooled donations will have been infected with hepatitis C. It's proposed that where claimants have received such products, then no further evidence will be required to establish that they were infected via blood products. Virtually all haemophiliacs will fall into this category. Just going back to the previous paragraph, paragraph 15, it's unclear from this why a standard of proof used in criminal proceedings might ever have been complicated or contemplated or thought to be a useful approach to adopt. But in any event, we see here what's said is that the lower standard of on the balance of probabilities should effectively allow for the difficulties that potential beneficiaries might face in finding evidence through records or being able to get evidence directly from
Well, it would follow, if this were the pattern adopted, that the absence of a medical record was and could not normally be decisive.
Precisely. But as we will see, the absence of medical records led in practice to many applications being rejected.
Well, I've read a lot of statements to that effect, individual statements.
Just one final part of this document, it's the next page, and it's the bottom of this page, under the heading Variations and Conditions. So we can see it says people who've received compensation as a result of a successful legal action against the NHS or an out-of-court settlement in relation to a legal action would have that deducted from the total award. People who've received compensation as the result of a successful legal action against a product supply would have that deducted from the total award. And then this, people who receive payments under the scheme would undertake not to institute future legal proceedings against the NHS or ministers in relation to the situation that formed the basis of those payments. And whether that is something that in practice was adopted is a matter I'm hoping to explore with Mr. Fish tomorrow. But you have heard evidence, sir, from one individual who had a recollection of, in relation to the Skipton Fund, of being asked to sign an undertaking. Although it's right to say the inquiry's investigations of the beneficiary files have not found anything to suggest that that was the practice. But it's a matter we'll want to take up with witnesses this week. So those are a couple of relevant documents which precede the establishment of the scheme. I want to turn next to the agency agreement that governed the way in which the scheme operated. It's at SKIP 5033_066, please, Shamek. So we've obviously heard a lot of evidence in relation to other financial schemes about the relationship between the trust or the body and the Department of Health. In relation to the Skipton Fund, the fund operated as an agent of the Department of Health. And this is the document that governed the relationship. This is the first signed agency agreement. There were then various variations as modifications were made to the scheme as the years went by. But you'll note the date, 22nd of May 2007. This is nearly 3 years after the Skipton Fund began to operate and received and began processing its first applications. Quite why it took 3 years for the agency agreement to be concluded is no doubt a matter we'll want to ask relevant Department of Health witnesses in due course. And again, you'll recall I asked Mr. Stevens about that. If we go to page 3, please, Shomik. We can see that it's the parties to the agreement of the Department of Health and the Skipton Fund Limited. And the background set out at A, on the 29th of August 2003, the Secretary of State for Health and Health Ministers of the devolved administrations simultaneously announced that a UK-wide scheme would be set up to make ex gratia payments for certain persons who were treated in the UK under the NHS by way of the receipt of blood, tissue or a blood product, and as a result of that treatment became infected with the hepatitis C virus. So we looked at the 29th of August 2003 John Reed press announcement. You'll see from this that, as I indicated, simultaneous announcements were made by the health ministers of the devolved administrations. If we go to the bottom paragraph on this page, please, we'll see there, in terms of then the relationship between the Secretary of State for Health as a party to this agreement and the devolved administrations. C tells us that the Secretary of State for Health and the devolved administrations have entered into a service level agreement by which the Department of Health acts on behalf of the devolved administrations in relation to Skipton, and the parties contribute their proportionate shares to the funds distributed. And if we go to the top of the next page, paragraph D, top of the page, Skipton has been formed to provide services acting as the DH's agent on the basis set out in this agreement. And then if we go just in this definition section towards the bottom of the page, you'll see there the reference to eligibility means eligibility of a qualifying person to receive a payment under the scheme. And it's decisions on eligibility that we'll be focusing on with the Skipton witnesses this week, because there was no discretion then as to the amount of payment. The payments followed a decision on eligibility. And then if we go to the next page, bottom half of the page, we can see here the terminology used by the Skipton Fund and by the Department of Health of stage 1 payments and stage 2 payments. And that was the lump sum payment of £20,000 to any person who, on the balance of probabilities, has contracted HCV because of receiving blood products or tissues from the NHS prior to September 1991, or in certain circumstances from a person who has received such treatment. And then stage 2, an additional lump sum of £25,000 payable to a qualifying person who has an advanced stage of illness due to hepatitis C virus because of receiving blood products or tissues, etc. And then if we go over the page, we can see a little further information as to who qualifies for stage 2 at the top of the page. Persons with cirrhosis or primary liver cancer and those who've received or are on the waiting list to receive a liver transplant are eligible to apply for a stage 2 payment. And then if we look at the, still on the screen, the scheme in italics, we can see what's meant by that: a scheme set up to make ex gratia payments to eligible persons alive on the 29th of August 2003. So there's the exclusion of those who had died prior to that date. And there, as part and parcel of the scheme, is the concept of these being ex gratia payments. If we go to the next page, we then see a little more in...
Could you just go
Yes.
back 2 pages from this? And again. Yes, that's fine, thank you.
So if we go on to, I think it's electronic page 6, or 7, thank you, that's it. So we can see here a little more about the relationship between the department and Skipton. 2.1, in furtherance of a policy initiative, DH has resolved to appoint Skipton as its agent to implement and administer the services in and throughout the UK. DH appoints Skipton to be its agent in the UK for the delivery of the services and carrying out of the services subject to the terms and conditions set out in this agreement. At 2.4, DH warrants it's the authorised representative of Scottish Ministers, National Assembly for Wales and the Department of Health, Social Services and Public Safety, Northern Ireland, together being all the devolved administrations responsible for the provision of the NHS throughout the UK. And then 2.5, and we looked at this with Mr. Stevens, it's an important provision. Skipton acknowledges that, 1, as a government department, DH is directly accountable to the Secretary of State for Health. 2, government policy is subject to amendment from time to time. 3, DH has a duty to act in accordance with the policy of the devolved administrations. 4, it, that's Skipton, may only alert DH to operational issues and may not make proposals to amend government policy. So that's the constraint that was placed upon the kind of matters that the Skipton Fund could raise. And again, you'll recall Mr. Stevens' evidence as to how effectively his understanding was he couldn't say anything about government policy or how the scheme should be reformed, but only raise what was termed operational issues. And if we look at clause 2.6 at the bottom of the page, Skipton acknowledges that the rights of DH detailed in clause 2.5 above shall be an overriding principle in the construction and performance of this agreement and shall take precedence over all other terms and conditions detailed herein, save that such rights shall not negate nor diminish the indemnity set out in clause 6.2. So the idea that the government policy is subject to amendment and was effectively part of the overriding principles in the construction and performance of the agreement. And then if we look further down this page, we see reference to Skipton's obligations. Skipton will provide the services in accordance with the specifications set out in Schedule 1. Skipton shall be responsible for providing the services and shall, within the scope of Skipton's resources, meet the service levels. And then if we go to the next page, clause 4.5, DH and Skipton shall meet every 6 months or as required to review operational issues, that phrase again, arising from the scheme. Additionally, both parties shall make themselves available for additional meetings on reasonable written notice from the other. If we go over the page, paragraph or clause 6.3, we can see reference there to the an independent appeals panel. DH shall, as soon as possible after the commencement date, arrange for the provision of an independent appeals panel to adjudicate on claims rejected by Skipton. So it was the Department of Health's responsibility to set up the appeals panel. And again, for reasons that are not entirely clear and may need to be explored with relevant witnesses from the Department of Health, that took over 2 years from the commencement of operations of the Skipton Fund, with the result that there was, I think, something of a backlog for the appeals panel when it first met in early October 2006. And obviously those who had had their applications rejected in that intervening 2-year period had no appeals panel to whom they could immediately go for reconsideration of their application because it had not been set up. If we then go a further 2 pages on, please, Shamik, just want to flag up the confidentiality provisions. Confidential information, this is clause 9.1, includes all information relating to the claimants as well as to the plans, intentions, affairs and or business of Skipton and the negotiations relating to this agreement. And then we'll see in 9.2, each party shall, subject to the DH's obligations to comply with the Freedom of Information Act and government policy concerning that act, keep all confidential information strictly confidential, not disclose any confidential information to a third party other than in limited circumstances. And if we just go further down, 9.2.3, use confidential information only in connection with the proper performance of this agreement. So a very wide definition of confidential information, not only relating obviously to individual beneficiaries where an obligation of confidence may be, the confidentiality would be entirely understandable, but also negotiations relating to the agreement and the plans, intentions, affairs and business of Skipton, all said to be confidential. And if we go to the next page, clause 9.4, we can see a prohibition at 9.4 on Skipton making announcements or public statements about the services without the prior written agreement of the Department of Health. If we then go to, it's probably electronic page 21, Shamit. Schedule 1, these are the services, so this is what the Skipton Fund was supposed to do as the Department of Health's agent. Paragraph 1, Skipton shall perform such services and no other as are necessary to administer the scheme. And then paragraph 2 provides for a registration process, so a registration form being made available by post and online. Then at 3, payments. On receipt of a completed application form for a stage 1 payment, Skipton will, having made appropriate checks of authenticity of both the claimant and the clinician supporting the claim, assess whether the claimant's eligibility for such a payment has been established on the balance of probabilities, and if appropriate, make the payment to the bank account supplied by the claimant on the completed registration form. So those are the 2 key elements of Skipton's work. The decision on whether the individual was eligible to be established on the balance of probabilities, and then 2, if so, the mechanics of making the payment to the individual applicant. That's for stage 1. Paragraph 3.2 tells us that when making a stage 1 payment, Skipton will tell the claimant that an application form for a stage 2 payment will be available on request. 3.3, where a claim for a stage 1 payment has been refused, Skipton will inform the applicant of the right of appeal. And then 3.4 tells us that the procedures for processing claims for stage 2 payments will be broadly similar. If a claim for a stage 2 payment is rejected, Skipton will inform the claimant that a further claim can be made in the future. I think the word made's missing, but a further claim can be in the future should their disease progress. Applicants whose stage 2 payment is rejected nevertheless have the right to appeal. And then over the page, under the heading appeals, an independent appeals panel having been provided in accordance with clause 6.1, Skipton will provide the Secretariat and organise all necessary meetings of the panel, prepare cases to be considered, record the panel's decisions and communicate the decision to each appellant. Mr Fish, as we'll hear tomorrow, acted as the Secretariat for the appeal panel as well as the administrator of the Skipton Fund. And then if we go to Schedule 2, which is on the next page, we can see it's headed qualifying persons, and we see a person is a qualifying person if, and then there is the reference to being alive on the 29th of August, so the exclusion of those who died, and who before September 1991, so there we have the date again, the cut-off date, was treated with NHS blood products or tissue, and as a result of that treatment on the balance of probabilities, became infected with the hepatitis C virus and developed chronic infection. people who acquired hepatitis C but spontaneously cleared the virus in the acute stage and did not develop chronic hepatitis C infection are not eligible for payments under this scheme. So there we see the exclusion of spontaneous or natural clearers in contrast to the first recommendation.
Well, it's not quite the exclusion of natural clearers. They would have to clear within the first 6 months.
Yes, within the acute stage.
And presumably, this is a question, the last sentence there, the issue of people who spontaneously cleared in the acute stage and didn't develop chronic hepatitis, that is also to be determined on the balance of probabilities.
Yes,
is it?
that's my understanding, but again, it's a matter to be explored with Mr. Fish and Professor Thomas.
Well, if nothing was said in what is a effectively legal document, it is a legal document, you would assume balance of probabilities unless some other standard were put forward.
Yes.
Yes.
And then we can see the second aspect of being a qualifying person. The first bullet point, a person who has haemophilia or other inherited or acquired bleeding disorders, whether or not also infected with HIV. This will include all those who've developed hepatitis C after being treated with factor 8 or factor 9 blood clotting factor, together with all those who have developed hepatitis C virus after being treated with any of the following products, and then we see them set out: cryoprecipitate, fever, plasma, whole blood, or any components thereof, provided that the treatment consisted of multiple doses. So that's the position for those who had bleeding disorders. And then the next bullet point deals with those without bleeding disorders who developed hepatitis C virus after being treated with any of the following products: whole blood or any components thereof, albumin, bone marrow, intravenous immunoglobulin, plasma, including fresh frozen plasma, and defix.
So what's the position of somebody who actually has haemophilia, but in the ordinary course of events has a blood transfusion for some other unrelated cause, and that transfusion is infected or contaminated? On the basis of this, he wouldn't qualify, or she wouldn't qualify, because there's a person who has haemophilia, and there wouldn't be multiple doses.
Yes, I don't know is the answer, sir, and that's a very good question to raise with Mr. Fish tomorrow. There are some guidance documents that I'll look at in the course of the morning. I'm not sure whether they help us answer that particular question or not.
Well, it's a matter of interpretation of the deed, and so the view of the administrator doesn't really take us very far, does it?
Only insofar as it tells us what as a matter of practice was done in such cases, or if such cases as a matter of fact arose.
Yes.
And then the third bullet point, so the third category of qualifying person, someone on the balance of probabilities becomes infected by transmission of the virus from a qualifying person in the categories above, if at the time of the transmission that person was in one of the following relationships with the qualifying person from whom the virus was transmitted. So this is what's I think termed in some places in the documents indirect infection, and such a person who is infected is a qualifying person only if they fall within certain categories of relationship: spouse or civil partner, other cohabitant, and then mother, son, or daughter of the mother. And then we see the second part of this, and the infection occurred as a result of sexual transmission from a mother to her baby, accidental needle stick injury, but limited to the relationships described above and excluding the sharing of needles by injecting drug users, or some other route verified by a qualified medical practitioner, but limited to the relationships described above and excluding the sharing of needles by injecting drug users. And then if we go to the next page, paragraphs 4 and 5, persons who qualify for and receive a stage 1 payment will be eligible for the stage 2 payment if they develop cirrhosis or primary liver cancer, or receive or are on the waiting list to receive a liver transplant. And then 5, no payments are made in respect of those who died before the 29th of August 2003. So that's the original agency agreement, signed, as I say, nearly 3 years after the fund itself began operating. If we look at one further document, you'll see a particular issue that seems to have arisen as a result of that delay. It's SKIP 5071_017. No, it's not that. Sorry, or maybe it is. Excuse me. It is. If we go to page 5. So this is an email from Mr. Fish to someone within the Scottish Executive. And he says in the second paragraph, I have a query which I would like to run by the Scottish Executive as they were responsible for the particular section of the agency agreement that I'm questioning as far as I'm aware. And that's the bit about indirect, those who are indirectly infected. A lady has applied to the Skipton Fund following a needle stick injury sustained whilst working as a nurse in England. The third party who she was treating when she sustained the needle stick injury was a successful recipient of the first stage payment. Since the lady is not, and then we see she doesn't fall within any of the qualifying relationships, not a spousal civil partner or in a similar relationship or a cohabitant or mother or daughter, it seems as if we've no option but to reject her application. Is this correct as far as you see it? Until this change was made, she would have been eligible for a payment, and it's possible that similar cases may have gone through, albeit a very small number, before this alteration was made. Seems to me that this lady deserves a payment but is excluded by the wording of the agreement. And I'll may want to ask Mr. Fish about that tomorrow. But you'll see it would appear from this that prior to the agency agreement being finalised and signed, the Skipton Fund had been taking a slightly different approach to needle stick injuries, where someone was infected through that route as a result of contact with someone who was themselves a qualifying person. The Skipton Fund was determining that they were eligible without requiring them to be within one of those qualifying relationships, but that changed, it would appear, once the agency agreement was formalised. The Skipton Fund, or the way in which it was set up, attracted criticisms from a number of quarters. I'm just going to invite your attention to one document in that regard. It's SKIP 5034_010. This was a submission from the Scottish Haemophilia Forum in March 2005. And you'll see in the first paragraph, the Skipton Fund arose only as a result of the campaigning in Scotland by the Scottish Haemophilia Forum, the motion supported by 80 MSPs from all parties, the unanimous support of the 1999-2003 Health Committee of the Scottish Parliament, and the decision of the then Health Minister Malcolm Chisholm, in reference to an announcement he made in January 2003. And then the perspective of the Haemophilia Forum then set out in the next paragraph. Since then, sadly, the work of the Scottish Parliament appears to have been hijacked by Westminster, and reference then made to the simultaneous announcements about what was going to be set up. And then you'll see in the third paragraph reference to the meetings being held in London at Department of Health offices in Skipton House, thus the fund has been named after a building, and so on. If we look over the page, we see the heading Issues of Concern, and then there are some particular concerns set out regarding the appeals panel process, I'm not going to go through the details of all of the concerns that are expressed, but there are a couple of more general concerns that I think merit attention at this stage. So paragraph 1, why is there a need to set up a private company limited by guarantee, given that its function will only be to administer the fund by sending out application forms, making payments based on a set criteria and rejecting others? 2, given that Skipton will be funded by public finance, why is it not part of a government department, thus ensuring that a minister be politically responsible and answerable to elected members? And then question 4, why has the money provided as an ex gratia payment to people infected with hepatitis C being used to pay the staff of Skipton? And then a series of questions about the appeals panel and how that will work. A number of concerns there expressed. Again, we may be able to explore some of these with Professor Mildred. If we go to the next page and we pick up at paragraph 12, where will hearings take place? 13, will the appellant be able to attend? So this is all about how the appeal panel might operate. And we know there were no oral hearings as such. There was no attendance by appellants. They were not permitted to attend. Question 15, will the appellant be able to have legal representation who will meet the cost? To which the answer is, if an appellant sought any form of representation, they'd have to meet the cost. And then at 17, how will appellants obtain expert opinion to challenge the decision of the medical panel? And again, we'll look at the practicalities of that when we look at some of the case studies. And then if we go a little further down the page, the paragraph beginning, we would urge the committee to amend the bill, remove the discrimination refusing payments to the dependents of those who've died prior to the 29th of August 2003. So concern being expressed by the Scottish Haemophilia Forum about the exclusion of those who had died. So that's just one example of concerns expressed about the arrangements that were made. Over the years of its operation, the scheme underwent several revisions. So initially there was, as well as the requirement that the people would be alive on the 29th of August, there was provision that a person who died after the 5th of July 2004 had to have applied to the Skipton Fund before their death. That was amended in around 2006, but the restriction on making payments to those who died prior to the 29th of August remained in place at that stage. It wasn't until 2011 that there were more substantive amendments to the scheme. So the stage 2 payments were then, and this is in the post-Archer period, increased to £50,000. Provision was made for a regular payment, and the scheme was finally opened to the estates of people who died prior to August 2003. I'm not going to go through the various revisions to the agency agreement, but the various iterations of the agreement have been disclosed to core participants. And then there were further changes in November 2016. Might be worth just looking at that. It's at SKIP 5031_042. These were revisions made by way of directions from the Secretary of State. So we can see the Secretary of State makes these directions by virtue of Clause 1.1 of the Agency and Services Agreement made between the Secretary of State for Health and Skipton Fund Limited. The reference there to the 24th of March 2011 is to one of the later agency agreements. And then we can see at paragraph 1, Skipton shall, in accordance with the agreement, pay each qualifying person the annual sum. So it was an uplift, an increase in the annual sums introduced in 2011 or thereabouts, and a bereaved spouse or partner a one-off sum of £10,000. So that was the introduction of one-off payments to bereaved spouses. And then we can see what the annual sums were, and we see here differences between the four administrations. So 1(2)A deals with the English provision in relation to a qualifying person for whom the Department of Health in England is liable to contribute funding. The annual sum is £3,500, of which £500 is designated a winter fuel payment, where that person is eligible for a stage 1 payment, and then £15,500 where that person is eligible for a stage 2 payment. So this, as of 2016, was the sum contemplated by way of annual payments in England. In relation to Scotland, we see at paragraph B, in relation to a qualifying person for whom the Scottish ministers are liable to contribute, at £27,000 where that person is alive and has received a stage 2 payment or a stage 2 top-up and is not infected with HIV, £18,500 where that person is alive and also infected with HIV and in receipt of an annual payment from MFET and has received a stage 1 payment. A different level from the English payments. And then if we go over the page, we can see the provision next in relation to Wales, which is the same figures as in relation to England. So £3,500 where the person's eligible for a stage 1 payment, £15,500 where the person's eligible for a stage 2 payment. And then at D, in relation to Northern Ireland, a qualifying person eligible for a stage 2 payment, a sum of £14,749, which seems a rather oddly specific sum. Those are the changes made in 2016, and we see there the divergence between the four administrations. There had then been proposals in the course of 2017 by way of the issuing of a consultation document for something called the special category mechanism. But those proposals weren't in fact implemented during the operation of the Skipton Fund. It was incorporated into the English Infected Blood Support Scheme, and we'll no doubt explore that with an appropriate witness in due course. So those are, as it were, that was the overall architecture of the Skipton Fund and how it came into existence. In terms then of how decisions on eligibility were made, there are 3 documents I'm just going to draw attention to. The first is SKIP 4031_248.
You're missing a nought somewhere.
So SKIP 5031_248. This is a document which it would appear would be available to, or might be provided to, potential applicants. This is one that postdates the 2011 revisions to the scheme, but we can just see it gives us some broad information about the process. So if we look at the bottom half of the page, how does the scheme work? We can see there again, the basic architecture of the scheme, the £20,000 lump sum payment, that's at A. And then at D, we can see the additional £50,000 payment for stage 2. So we can see it's after the increase from £25,000 to £50,000. F tells us that it will be assumed that people who've developed hepatitis C after being treated with factor 8 or factor 9 clotting concentrates were infected as a result of that treatment. Virtually all haemophiliacs will fall into this category. At G, no payments will be made in respect of those who cleared the virus spontaneously in the acute phase of the disease. And then H, the scheme will not pay any legal costs that people incur in preparing a claim for payment from the Skipton Fund. So there's the answer to one of the questions raised by the Scottish Haemophilia Forum. And then we go over the page. We can see here the mechanics of the application process. So how do I apply? 1A. If you want to apply for payment, you can do so by completing the online registration form or applying direct to the Skipton Fund. Paragraph B, the Skipton Fund will send you an application form containing comprehensive guidance on how to use the form. After answering a few questions concerning your application and signing the form, you should then pass it to your doctor, who will answer the questions that relate to your illness and how you might have been infected. And that's an important feature of the process. Most of the work was expected to be done by a doctor, and it was the clinical opinion that was sought, with there being very little scope at the first stage, the application stage, for an individual to provide any form of additional supporting information. And then if we go to a little further down the page, what happens once the form has been completed? When the form is completed, your doctor will send it to the Skipton Fund. So that was the process. The applicant would put in their details. They then provide it to their doctor. Their doctor was supposed to complete the rest and send it off. B, the Skipton Fund will then check the information on your form. If further information is required, the Skipton Fund will write to inform you or the doctor who completed the form. And then 3, what happens if my doctor is unable to provide the information required? If your doctor's unable to provide the necessary information, e.g. because some or all of your medical records are missing, they'll send the form to the Skipton Fund anyway with an explanatory note. The Skipton Fund will then write to you explaining what action should be taken. And then 4, what do I do if I disagree with the Skipton Fund decision? A, if you disagree with the decision of the Skipton Fund, you can appeal. And then if we go to the next page, Skipton Fund additional information. If we go, towards the bottom of the screen that we can see, the question, will I have to prove that it was NHS treatment that caused me to have hepatitis C? The Skipton Fund will consider applications on the balance of probabilities where there is evidence of an applicant receiving blood or blood products, including factor 8 or 9 blood clotting concentrates. Can I see what my doctor has written about me on the application form? You are entitled to see the answers your doctor has made to the questions in the application form. If you want this information, you should ask your doctor. So an applicant would not even be in a position, unless their doctor gave them a copy of the completed application form, of having their own copy of the completed form. There was no provision for the doctor to complete it and then give it back to the applicant, who would then send it off. The route was set up to be via the clinician, which raises obvious potential difficulties when it comes not least to questions of appealing. And then if we go towards the bottom of the page, the penultimate bold question, do I need the help of a lawyer when applying for a payment from the Skipton Fund? It says the Skipton Fund application process is designed to allow people to take forward their application themselves. The forms only require you to provide very basic information, and your doctor will supply the necessary medical input. Therefore, there is no need for you to consult a lawyer. You're free to seek legal advice if you wish. For example, if you're considering appealing, the decision's yours, but please note the Skipton Fund will not pay any legal costs you may incur. So that's one document about the process relating to Stage 1 applications. In relation to Stage 2 applications, if we go to CVHB 609_118, please. So this is a guide to applications for Stage 2. If we look at the question, the second main question, how do I know if I qualify for the additional payment? In order to qualify, you must first have received the basic £20,000 payment from the Skipton Fund. Provided this is the case, you should then automatically qualify for the additional payment if, and then we see the reference to liver transplant or waiting list or liver cancer. Alternatively, if you and your specialist doctor suspect or have confirmation that you have an advanced stage of liver damage called cirrhosis, you may also qualify. So not there put as an automatic qualification in the way in which this document expresses itself. And again, that's a matter that we'll need to explore with witnesses this week. And then I think I qualify for payment, how do I apply? And reference is made to application form. If you've advanced liver disease, you will almost certainly be under the care of a specialist doctor or consultant. You should take the application form to that specialist and discuss whether your present condition is likely to qualify you for the payment. At bottom of the page, how do I get the evidence that I need to apply for the additional payment? Again, reference is made to the specialist doctor who'll be asked to complete the application form. by providing evidence based on tests or medical history. Over the page, under the heading the application form, we can see after the first question it says the medical questions in the application form are not designed to be completed by you personally. They should be completed by the specialist doctor looking after your liver condition. And then the next question, my specialist doctor and I agree I'm likely to qualify for the additional payment. What do I do now? And then reference is made to the doctor, in many cases, being able to complete the form using information from medical records. And then the next paragraph says this: if you do not automatically qualify for payment and do not have the necessary medical information or test results in your medical history, your specialist will need to arrange for further non-invasive tests to determine whether you're likely to have cirrhosis. And then further information is set out about that. What tests might I need to have? Reference to a liver biopsy, but that being an invasive procedure which carries an element of risk. And it says your specialist doctor will not carry out a biopsy just to support your claim. And then in the last paragraph, references to various blood test results, which may be sufficient. And then if we go over to the next page, again, there's more information about the process of testing. And if we look just above the big heading when the application form is completed, we can see it says the results of the blood tests may not always provide a clear-cut answer. In such cases, the application form gives your specialist the opportunity to provide other supporting evidence, such as that obtained from a physical examination, other blood tests or any scans, etc. you may have had that might be helpful in deciding whether you're likely to qualify for the additional payment. And then under the heading when the application form is completed, if we go a little further down the page, you'll see there's an italicized paragraph: the Skipton Fund cannot make a payment without the information your specialist doctor can provide. And then the next paragraph says if you wish to see the information that's been supplied about you, you should ask your specialist doctor for a copy of the completed form. So again, the route is the doctor completes the key parts of the form, sends it off to the Skipton Fund, and the applicant only has a copy if their doctor provides it to them. So that's the information about stage 2. And then there's one set of internal guidance, which I'd like to look at before we take a break. SKIP 5030_045. So guidance on assessing an application for the £20,000 payment. Evidence is defined as information supplied on an application form, and well, we've seen the application form insofar as the applicant is concerned, there's a few basic questions. So the bit of the application form which makes provision for substantive information to be provided, is that completed by the doctor? Authentic documentation, e.g. from any NHS establishment to the National Blood Service, etc., opinion, confirmation or signed authority from a practicing clinician, or attestation by an authorising signatory that the claimant has no history of intravenous drug misuse. So no provision there, for example, for personal statement by the applicant or the applicant's parent or the applicant's spouse or sibling setting out recollections of receipt of a blood transfusion. That's not included in this list of or definition of what's said to amount to evidence. Then we see a series of questions, and we can see this is relatively early guidance because it predates any of the changes. Section 1, is there evidence that the claimant is alive or died between 29th of August and 5th of July and has been / was chronically infected with hepatitis C for a period of more than 6 months? Yes, continue with the section. No, reject application. So that's the initial assessment of whether it's a qualifying person. Is the claimant a primary infectee? Yes, continue with this section. No, go to section 4. Is the claimant a haemophiliac? Yes, go to section 2. No, go to section 3. So we then need to follow through the decision-making process. Section 2 is for haemophiliacs, which I think is a shorthand for all those with an inherited bleeding disorder. Is there evidence of NHS treatment with factor 8 or factor 9 blood products before September 1991? Yes, approve application. So that effectively is all that's required. No, continue with this section. Is there evidence of NHS treatment with other blood or blood products before September 1991? Yes, continue with this section. No, go to section 2. Well, this is section 2, so quite how that's meant to work is unclear. Next question. Is there evidence that a source of infection other than NHS blood or blood products could be responsible for the claimant's infection? Yes, reject application. And so you'll see that that question is repeated in the other sections of this guidance. So this would seem to suggest that the existence of any evidence that there's a possible source of infection other than NHS or blood products was supposed to lead to the application being rejected, rather than an approach of assessing on the balance of probabilities which was the likeliest cause of infection.
Yes, it looks very much like proof beyond reasonable doubt.
Yes. And again, it's an issue we'll want to explore with relevant
Indeed, the doubt
witnesses.
isn't necessarily reasonable. It could be.
Yes, absolutely. So that's section 2, haemophiliacs. Section 3 is then non-haemophiliacs. Is there any evidence to suggest that the claimant's infection occurred because of exposure to NHS blood or blood products before September 1991? Yes, continue with the section, no, reject application. Over the page. Is there evidence that a particular course, incident or course of treatment was responsible for the claimant's infection? Yes, continue with this section, no, reject application. So the claimant has to pinpoint a particular incident or course of treatment, otherwise their application gets rejected according to this. And then the next question we see framed in the same way as in relation to haemophiliacs. Is there evidence that a source of infection other than NHS blood or blood products could be responsible for the claimant's infection? Yes, reject application. Only if no, there's no evidence of a possible other source, does the application get approved.
So what is the position, applying this guidance strictly, to someone who comes to have hepatitis C identified in the early 1990s, who has in the 1970s had 1 transfusion, 1980s 2 more? They can't necessarily say which particular incident or course of treatment caused it.
No, they can't. Whether that would have led in practice to a rejection is unclear. I don't think we've seen any individual files that would suggest that that approach has been taken, but we may not have seen any individual files on those particular facts. The practical impediment that seems to have been faced by many applicants really is either the absence of what was regarded as acceptable evidence, i.e. almost always records, medical records, or a suspicion being raised that there might be another cause, in which case applications, according to this, fell to be rejected, and we've seen some support for that in the individual files that we've examined. I'm not going to go through the series of questions for section 4, indirectly infected claimants, but again, there are a series of questions there set out, and there's a similarly phrased question, the 4th question. Is there evidence that a source of infection other than that of exposure to the blood of the primary infectee in a domestic environment could be responsible for the claimant's infection? Yes, reject application. So I note the time, and I'm going to move now to probably a slightly different topic, and just to look briefly at the appeals process. So is this a convenient moment for a break?
Yes, we'll take a break until 11:45. So 11:45.